We
I
want,
think we're good to start,
yeah,
right?
sounds good to me.
All right, thank you for everyone for joining. I am the IP Hawk. I'm joined with Gaston from Markman Advisors and Dan. Dan, I'm not exactly sure where you're at.
I'm a partner at Zeisler PLLC.
So it's really great to have two patent attorneys on the call to kind of get real-time analysis right after the opinion. We were originally just going to do this over Biogen, but the appeal kind of came out yesterday morning, which was pretty exciting. And I think all three of us are pretty happy on the results, as we kind of nailed it.
If I may say so myself, I think we were not only accurate as to direction, but also as to timing, which is an important concern. For my part, and I'm sure Dan agrees, there's nothing as valuable in terms of handicapping a case as getting to hear these Federal Circuit oral arguments, especially when you have a background knowledge of the judges and their predilections, and appellate law experience, where you can kind of tell by the tone and tenor of the questions being asked, exactly what's on the mind of the court. And I thought that these set of arguments were very helpful in that regard.
Yeah,
Yeah,
absolutely.
it's really great that they are live streaming the audio version. I really wish they would do a video because you can really see some interesting things from the judges, shifting, hand waving when you're there in person. So hopefully they'll add that down the line and definitely keep the online streaming of the hearings.
Yeah, so, yeah, just as a refresher,
Yeah. Set us up, Dan, with what happened.
yeah, just as a review, I'm sure everyone already knows this. So, even though there is currently no pending litigation that we're aware of between Moderna and, how do we say this again? Arbutus? Abus?
Got yelled at by a few people. It's Arbutus.
Arbutus. Okay.
Arbutus.
Okay. Arbutus has a very large patent portfolio. For whatever reason, Moderna has been motivated to try to nullify some of those patents, and Moderna's attempt to nullify those patents was rejected by the patent office. Moderna asked the Court of Appeals to overturn the patent office failure to nullify these couple of Arbutus's patents. And yesterday, the Court of Appeals refused to do that, and while dismissing one case, effectively affirming both patent office decisions not to cancel Arbutus's patents that were challenged by Moderna.
Yeah, so I think this puts Arbutus in a really good position. A bunch of questions came down through the feed that I'll start running through. But the appeal, how it resolved, was definitely encouraging. What would be the next steps at the Federal Circuit?
Yeah, so the first thing Moderna can do is petition for a rehearing of the appeal, either by the same three judges that already heard it, and or by the entire Court of Appeals as a whole. So that's called petition for rehearing, and or petition for rehearing en banc, where en banc means the court as a whole. Do I expect them to file these petitions? Perhaps. Do I expect them to have any chance of being granted? No. Then, if those aren't granted, then Moderna's last available opportunity to have these decisions reviewed is to ask the Supreme Court to take the case. And again, there's no chance, in my opinion, that the Supreme Court will take these cases. So, as far as I'm concerned, the decisions issued yesterday are going to be the last and final decisions in these two matters.
Yeah, just to add some color, I agree with Dan on that. So, one of the things that stands out here is that the three judges, both opinions, there was no dissent, meaning all three judges on the panel agreed with the result. So in a case like this, where it's pretty much a straightforward appeal from a PTAB or patent office validity proceeding, set of validity proceedings, that with no dissent and no real, I think, major topics of interest that could apply across other cases, I really see very little in the way of meat on the bone for any rehearing to take root at the Federal Circuit. Now, considering now that might have been a little bit different in my view had the Federal Circuit thrown out the Moderna's IPR on standing grounds with respect to with the 069 patent, because I believe they did make some what I would call public policy statements building off a case that Dan was involved in, but they kind of went the more conservative way here by saying actually Moderna does have standing because we're going to take into account just the totality of the circumstances around the threat of infringement, some of Arbutus's prior statements that Moderna was a target. So, I think the result kind of suggests that there's not going to be a lot of meat for rehearing, but had that determination gone the other way, these rehearing requests, or as I agree with Dan, on a Supreme Court escapade to get the Supreme Court to try to review this, why would they even bother? And the answer to that question, I think, is buying time. At least in my view, you want to delay, keep the issue alive as long as possible, to the extent that that helps delay Arbutus filing an infringement lawsuit against Moderna, so as not to give Moderna standing. That could be valuable in and of itself. So I definitely agree with Dan that the likelihood of this case continuing in its current posture past this point, other than in terms of delay, is actually very, very low. But there still may be, good business justification for Moderna to push the issue as far as it can go because, again, buying time.
Yeah, and as we talked about before, this kind of goes into what happens next. And some people said, well, why hasn't Arbutus filed an infringement suit against Moderna now that they've won? Well, the issue of standing went in Arbutus's favor because they haven't sued Moderna. We talked about this last time. And these two cases are still live. They're not done yet. So if Arbutus was to sue Moderna now, Moderna could use that fact to go right back to the Court of Appeals and say, hey guys, they sued us, now we do have standing, and the appeals are still live. So if and when there's going to be an infringement lawsuit filed by Arbutus against Moderna, I would expect that not to happen until Moderna has exhausted all of its rights to seek further review of these decisions, which include the en banc rehearing and the Supreme Court petition. So I won't expect a lawsuit to be filed, and that process will take probably a year. So we're talking at least a year. But it is clear Moderna really tried to convince the court that Arbutus is going to sue them. If you read the opinions, there's this Mr. Ryan at Moderna, who's Moderna's senior vice president and deputy general counsel, and Ryan described that from Moderna's perspective, Arbutus has actually done things and said things that have created a substantial risk. Arbutus is going to bring an infringement action relating to Moderna's COVID-19 vaccine. And Ryan pointed to some public statements made by Arbutus. And Moderna is already a sub-licensee to some patents for some other molecules. So it's clear that Arbutus has not crossed the line into suing Moderna because they don't want to provide standing. where it doesn't already exist to challenge their patents, but that Arbutus has sent all the signals we expect that they will file an infringement lawsuit as soon as they can do so without diminishing their standing arguments in these cases.
Yeah, and I think to build on that, I mean, IP Hawk, I mean, would you agree that the Arbutus, in addition to the standing question, would probably also be careful about suing a vaccine maker in the midst of an ongoing pandemic? So buying time is not, doesn't necessarily hurt Arbutus either, right?
No, I would say buying time is okay for Arbutus, and if they have to wait 8 to 12 months to file something, and hopefully we're really out of this pandemic at this point and they're just recovering some lost profits, it won't be, I guess, looked down upon by a potential jury or the judge in the case.
And patent holders have 6 years. When you file a lawsuit, you can get damages for up to the past 6 years. So it's not like by delaying filing a lawsuit, Arbutus is losing the right to recover some damages that are occurring.
Yeah, and I think as a patent litigator, I think it's important for the audience to understand that getting a patent lawsuit on file is actually really easy to do. It's the kind of thing that you can pull the papers together if you needed to. In a very short period of time, on the order of a couple of hours. The opening pleading in a case is often a very straightforward complaint. Now, that doesn't. I'm not trying to minimize the amount of work that goes into, confirming that you have, an infringement read and that you have an actionable damages theory. That all takes time, but the time from when you know who your target is, where you want to sue them, and to actually getting a lawsuit on file is not something that is that expensive or that time consuming. The real issue is before you commit on that strategy, are you prepared to take it all the way? And I think that's one of the considerations that investors have to look at here, which is Arbutus really set up right now to go after Moderna and sustain what's going to be a very difficult patent litigation, which is going to be orders of magnitude different than defending some patents in an IPR proceeding in the patent office.
I have a follow-up question related to this. Where would you file the case? What venue? Would it be in Delaware? Would it be New Jersey?
Well, the venue, there's a Supreme Court decision on venue a few years ago that makes where you file patent cases different than most other federal cases. In most federal cases, you can sue a defendant anywhere that they have a presence or where they have purposefully availed themselves of the benefits of that state. The Supreme Court's decision a couple years ago, T.C. Hartland, says the venue statute requires that you can only sue a defendant in the state where they are incorporated or where they have a principal place of business. So it was a decision that gave a real hometown advantage to defendants.
Yeah, and I think in Moderna's case, I'm assuming that I haven't double checked, but I'm assuming that they're a Delaware company, which would mean Delaware would be one place where you could file. I'm on Moderna's website right now to see where they have physical places of business or offices, and it looks like they're in the biotech corridor up in Massachusetts. So, both Delaware and to a lesser extent Massachusetts definitely are federal courts that have significant patent experience, smart judges, but you are. It doesn't seem right off the bat that that Arbutus would be able to take advantage of Texas, which is where a lot of patent cases get filed because they're considered more pro-plaintiff. So there's advantages and disadvantages in the consideration between Massachusetts and Delaware. But like Dan correctly said, it's not like we have all 50 states to work with respect to where Arbutus would be able to file their case.
I guess the second part of my question, could you see Moderna kind of pushing Arbutus to file with a declaratory judgment action, saying that they don't infringe?
That's a double-edged sword. You can always bring a DJ in order to address perceived legal risk. But then you've started the fight. And so you may want to postpone beginning the fight until the fight is brought to you. So I'm sure those conversations about whether to file a DJ or not have happened. I wouldn't advise it because there's no real need for Moderna from a business case to provoke a very expensive and lengthy patent lawsuit to start sooner than it otherwise would. But now with these decisions, maybe Moderna is going to consider doing that. You used to file DJs in order to get home field advantage, because if you file a DJ against a patent holder before they've sued you and they want to sue you in their home court and you can file the DJ in your home court, it was a way to fight over venue. But then once the TC Heartland decision came out and said patent holders can't sue you in their home court, patent owners have to sue you in your home court, it kind of got rid of the motivation, any of the benefits of the DJ.
Yeah, I would agree with that. I do think that, under the current system of patent litigation, DJs that do get filed are usually filed by companies that may be susceptible to venue in Texas and don't want to get sued in Texas, so they'll file in California or somewhere else first. I don't think you have that consideration here. I do think, though, that based on the Federal Circuit's comments, particularly in the 069 decision, that Moderna could consider a DJ, would likely survive a motion to dismiss, that there is an actionable controversy between them and Arbutus. But I think at the same time, I agree with Dan. I don't really see much benefit to Moderna to provoking this fight any further than they already have. And I also think it's important to keep in mind that Moderna, in any lawsuit going forward with respect to these patents, is going to be fighting with effectively with one hand tied behind their back, based on whatever estoppel on validity is going to attach to these particular patents. So I think if I was in Moderna's position where I'm raking in the money, I know I'm going to be well resourced to take a fight to the bitter end if I needed to, and I'm confronted by a company like Arbutus, which is much smaller in size, may or may not have the wherewithal to or the know-how. To be quite frank, not every biotech company knows how to successfully structure an enforcement campaign. I might just decide to wait and see. And let Arbutus make the first move, secure in the knowledge that I can hit him back with, whatever is available to me when I need to.
I guess my next question would be, how long would an infringement lawsuit drag out? From filing to kind of a jury verdict and the appeals? Is it something 3 to 5 years? I'll address that, but before I do, I just wanted to also make one last point that just popped in my mind. The question of whether or not a DJ filing by Moderna could impact on the standing issues, it's something that, maybe they're also thinking through as well, right? We've talked already about this idea of maybe Moderna wants to extend this process as long as possible to try to delay Arbutus from filing against them. Filing a DJ would obviously undercut that. But to turn to the other question of how long does a patent case take, both
assuming we're working with a universe of either Massachusetts or Delaware, I think your 3 to 5 year time frame is a realistic one. There is going to be a lot of attention on the case, but at the same time, it's not going to be a situation where I think Arbutus is going to be able to move for something like a preliminary injunction. So it's really going to be a straightforward royalty play in my view. And both courts are busy with a lot of other things. Delaware in particular, which is chronically understaffed in terms of federal judges, and now with Judge Stark being nominated to the federal circuit, they may even have another vacancy, which would slow everything else down in the Delaware court. Believe me, Arbutus is plotting this out as we speak, and one of the considerations I think in the question between Massachusetts and Delaware would be, how long is this going to take?
Yeah, if Moderna wants to play hardball, which is what I would generally recommend if I was representing them, this could last 7, 8 years, if not longer, because the patents that have survived IPR now can still be asserted in court. Massachusetts and Delaware are very good courts, but they're not fast courts compared to Texas and Virginia and other places. And then you have an appeal, and in these cases, damages is if Moderna wins, if Arbutus wins, they're going to have to get damages. And one of the most difficult issues to have affirmed on appeal is damages, because the law of damages is very unpredictable, and a lot of district court judges are not applying it in a way that the Federal Circuit approves. So there's a very high chance that this case, when it gets filed, you could have 3 years at the district court, then a year to a year and a half at the Court of Appeals, and the Court of Appeals could remand it for some issue. The issue could be validity, the issue could be infringement, or the issue could be damages, and then they remand, or claim construction. There's all sorts of issues that could require a remand. So then the remand goes back down, and then you've got it back at the trial court for another 2 years, and then it goes back to the Federal Circuit for another year to year and a half. And there's a lot of cases that follow that kind of up to the Court of Appeals, back down to the trial court, then back to the Court of Appeals process.
Yeah, I think it's important to consider the time frame of similar type cases, and putting aside the difficulty of winning on the merits. I do think that in these complex bio cases, when you do add a damages component, like Dan said, your appeals risk goes up a lot higher. That being said, if I'm advising Arbutus in this, I am hoping to do everything I can to convince Moderna to settle for as much and as quickly as possible in the process. And if I'm Moderna, I am pushing the day of reckoning as far back as I can go. So to some extent, patent litigation, big ticket patent litigation, very much represents a game of chicken. And part of the fun in watching these situations unfold is seeing what the companies do to position themselves to get to where they want to be. And I haven't seen a lot yet from Arbutus' side about what the plan is to actually go after Moderna. I've seen a lot of kind of talk about the potential of it, but concrete planning, we wouldn't expect to see it. It would be confidential, but that's going to become very evident once we see what they ultimately do, when they do it, which court they file in, which lawyers they use, whether or not they acquire more patents, which patents they decide to assert. All these things are very important in terms of evaluating Arbutus' chances for success in the litigation going forward.
Yeah, I'm kind of waiting for the eventual patent complaint to get filed. It's mostly a lot of speculation and conjecture. I would say with patent anything related to the patent world, things happen fast, and then there's a big lag in between, and everybody is kind of waiting around to see what the next, I guess, key event is going to be. So that is definitely very common. I wanted to ask a quick question about the COVID vaccine patent waiver the White House is looking for. Do you see any impact that might have on any potential case?
No, as far as I understand it, the vaccine waiver is more of a compulsory license. And under the compulsory license rules, the patent owner would still be entitled to some compensation. We have other laws that permit the government to infringe patents or to contract with a party to infringe a patent, but the patent holder still is entitled to some compensation. And the vaccine, I thought the whole vaccine patent waiver was just a political tool to get the United States to supply vaccines to the world. And I don't see that impacting materially the financial prospects of a case for Arbutus against Moderna or any of the other vaccines.
Yeah, I would agree with that. I think I also think it's important to kind of, for context purposes, to keep in mind that while patent litigation is important and often involves companies that are with market caps in the many billions, like Moderna here, and sometimes a smaller player or an equal sized player on the other side. One of the funny things about patent litigation is that the companies can be very big, the amounts discussed can be very high, but we still live in a world where $100 million is a big number in a patent case, and you know this well at IP Hawk. And the amount of fighting you have to do to get a $50 million verdict is the same as you have to get a $500 million verdict. But anything over $100 million is both rare and usually indicative of a multi-year process where the defendant's going to fight like heck not to have to pay for as long as possible.
Sitting in many Markman hearings, trials, appeals, you basically have two parties that hate each other's guts, and you either get a jury verdict that goes all the way to Supreme Court until appeals get exhausted for payment, or there's a coming of the minds, a budget, some key decision maker panics. That's kind of when these big deals get crossed. But until the situation kind of escalates, nothing. Getting a 9-figure or 10-figure payment is very, very difficult.
Yeah, and so people say, how long is it going to take, and then how big is it going to be? Well, the only way this resolves soon is if it's a very low price, because Moderna's not going to pay a lot of money until they've put Arbutus and its patents through the ringer. And the odds are with defendants in patent cases, because a defendant only has to prove they don't infringe, or the patents are invalid, or that the amount of damages available is nominal or very low. Any of those is a win for the patent holder. For the defendant. On the contrary, it's very hard to win as a patent holder because you have to defend the validity of your patents, you have to prove infringement, and you have to prove entitlement to a large amount of damages. So it's a hard road to hoe. And when you look at the resources, I'm looking at Arbutus's most recent 10Q, and they're losing tens of millions of dollars a year. And they're an under a $1 billion market cap company. So are they capitalized sufficiently to wage an 8-year war? What could be an 8-year war? It could also be a 5-year war, but it's going to be somewhere between a 5 and 8-year war against Moderna, which has substantial cash flows, and there's no question about the capital structure of Moderna being able to wage this kind of war.
Yeah, I think looking at this situation, it's always interesting to see similar cases that have unfolded, and one that comes to mind right off the bat is there was a dispute that played out over the past couple of years between Kite and Juno with respect to CAR T therapy, and it actually followed a similar track where Kite was first to FDA approval. Juno had access to a Memorial Sloan Kettering patent that they argued covered a very key aspect of the technology. Kite kind of proactively tried to IPR the patent that Juno held, lost, and the case eventually got filed, went to trial, and Juno won a $1 billion plus verdict. In the meantime, both companies ended up getting acquired by bigger companies. I think there was one Celgene and I think BMS, but I'm not sure. I know Celgene for sure acquired Juno, and ultimately the whole thing fizzled out when the Federal Circuit found that the patent was invalid on written description grounds. So, I think there's a lot of parallels between that situation and this one, and I also think it's going to be very interesting to see. Could Arbutus either get acquired in the meantime? 8 years or even 5 years is a lifetime in this industry. Who Arbutus ends up partnering with, getting acquired by, whatever, could go a long way to determining what the ultimate result is here.
Yeah, I would even say, could Moderna just throw them $1 billion and make the whole thing go away? That's, I would say, certainly a possibility, especially if there's documents that Moderna might have that would be damaging for the patent case if it became public during discovery, and I guess the heightened controversy surrounding the vaccines, that if there were any documents or information produced in discovery that might damage their reputation becoming public, writing a $1 billion check would be nothing for Moderna at this point.
Yeah, so I don't want to get too far down the patent law rabbit hole, but for example, one of Arbutus's patents has in its claim language what we call a transitional phrase, consisting essentially of. So when your patent covers what's described in these sentences at the end called claims. These sentences can either be open-ended or closed. So for example, if I say I claim a table comprising 3 legs, well, a table that has at least 3 legs or more infringes. If I say a table consisting of 3 legs, then only a table with 3 legs infringes. If you put a table with 4 legs, it doesn't infringe. So there's a huge difference between the word comprising or consisting of. When between the two, we have this middle language called consisting essentially of, which is closed except for it allows non-material additional things to be added. So the claims here are consisting essentially of, and then they list the elements in RNA, cationic lipid, etc. So that is a good argument for non-infringement, because you can say our vaccine has additional components that render it not infringing this consisting essentially of language in the patent. So that's one of the issues that I can guarantee you is going to get litigated at the district court and at the federal circuit, because that's a huge issue regarding what does the patent cover, what's not covered, based on one word, essentially.
Oh yeah, I mean, I think there's, even with these losses in the patent office, Moderna will have plenty of arguments to make, both on the merit side of things and on the damages side as well. I would say that one of the and maybe this is a way to transition to the discussion on Biogen if we still have time to do it, or maybe we'll save it for another day. But there's not only ways to kill a patent based on what people knew in the past, what we call prior art, but sometimes the way the patent itself is drafted can lead to very powerful arguments for defendants like Moderna. And I don't think that's been explored yet in detail. At least I haven't seen it. But I can assure you, to the extent that Moderna is able to identify challenges to the Arbutus patents based on the way they were drafted under what we call Section 112, they will do so. So I think we're in, there's still a long way to go in this, but it's definitely a very interesting dynamic between the fact that probably 3 years ago, Moderna never expected to be in the position they're in terms of the revenue they're generating with the COVID vaccine. And Arbutus, has had some success so far, but, I would hope appreciates that it's a long road ahead to getting big money out of Moderna here.
Yeah, I like to use the analogy, being a patent owner is kind of like playing a video game, whether it be Mike Tyson's Knockout or Donkey Kong. Surviving a level and getting past that feat is a very good thing to celebrate. That's congratulations, but you're still a long way away from winning the game. So you've got to get through 9 different boxers to win Mike Tyson's Punch-Out, and the last one is the hardest one. So winning the patent office decisions was a successful win and should be celebrated. Getting those decisions affirmed on appeal yesterday, fantastic win. But there's still a number of more wins Arbutus has to achieve in order to realize cash in exchange for its patents.
I think that's a really good point. There's hundreds, if not thousands, of cases that have gone very well and, hit a roadblock at the claim construction hearing, summary judgment, dauber, an expert thrown out, and it torpedoes the whole thing. So that's a really good point.
Yeah.
At the same time, the potential what Arbutus may be able to accomplish with their patents is really fantastic at this point in time, right? If they're able to sell the company because someone likes the potential of these, of the ability to go after Moderna, if they're able to, beat the odds maybe and get money out of Moderna, there's very few things, assets that a company can have that offer the same potential bang for their buck as patents do. So, but it's, to extend Dan's analogy a little bit, when you sit down to play the game, everything's in front of you, and that's what makes this field very exciting. Once you're on a particular level, though, once you're playing a certain board or fighting a particular character, your focus has to be about beating that character and getting to the next level. I think now we're at a point where Arbutus is, they've gotten through a level. Now they have to decide when do they want to sit down and start the patent infringement game against Moderna, and that's going to be very exciting to watch going forward.
And it's like a startup company. You invest in a startup company before they've got their product, and so getting a product launch is great. Getting users is the next step. Getting revenue is the next step. Getting profits is the next step. Scaling up. So successful patent assertion is very comparable, and the risk reward is very favorable. At, let's say, very conservatively, by which I mean aggressively, Arbutus has to spend $5 million a year on lawyers. Let's assume they're spending $5 million on lawyers to assert these patents against Moderna, which is a very fair budget. And even if it takes 8 years, that's only $40 million. So you're spending $40 million. What odds do you need for that to be a rational investment, given how much money you can win if things go your way? I mean, you don't have to have great odds to spend $40 million when you're looking at 10x, I don't know, 20x your money. It's a no-brainer investment decision.
Yeah, real quick, we got a lot of questions regards to valuations and numbers. I would point people to some tweets that Patent Pundit Patent put out yesterday that I thought were pretty well done. I haven't verified the source of it, but he's a really good, I guess, person to follow, and always has really, really good information. Do you guys have enough time to tackle Biogen?
I have a 12:30, but I can go for another 10 minutes or so.
Yeah, I again, I was surprised that there were 3 judges, and 2 of the judges, Rainier and O'Malley, we knew what they were going to say. So the case really came down to Hughes. So the deciding judge actually didn't write any of the opinions because he just joined Rainier instead of joining O'Malley. I've expressed my opinions on this before in writing and other places. I think the district court just got it wrong, just a flat wrong application of the law. I agree with O'Malley's dissent entirely. In this case, unlike the Moderna cases, which I think have no chance of being heard either en banc or at the Supreme Court, I think Biogen has very good odds. I've actually heard from other people already in the pharmaceutical biotech industry who may come to Biogen's support and submit briefs, amicus briefs we call them, supporting Biogen's petition for rehearing en banc. And this issue of written description that's involved in the Biogen case is a very controversial issue. It's a new issue. It's only been around for a few years. The court hasn't explored it very in-depthly. So I think there's a real chance that Biogen could get the case reheard en banc. We'll see that process play out over the next few months.
Yeah, I would say that unlike the Arbutus Moderna, where we noted the lack of a dissent as a factor in our prediction that those cases would not get reheard. Here, you have I think, quite fundamental disagreement between Judge O'Malley and the 2 judges that ruled against Biogen here, Judge Hughes and Reyna, about whether or not the judge in West Virginia handled this issue properly. Right, and in particular, Judge O'Malley seems to believe, and in what I thought was a persuasive dissent, suggests that they overstated what the patent needed to teach, and that the judge made a critical error in what she called not adjusting the lens through which it considered the evidence and testimony. So I think there's a lot of things that are in Biogen's favor here, including the fact that this patent has survived on other validity grounds in the Federal Circuit before. That a rehearing could be likely in this situation. I also agree that the application of the written description requirement as a tool for invalidating high-value pharmaceutical patents is a relatively new phenomenon, and in fact, it actually extends to the Juno case that I mentioned before, which I believe may also continue to be on appeal. And whenever there's an issue that touches across a number of cases, and it seems like there's a dispute within the Federal Circuit as how best to address that issue, your odds of further consideration go up, as do your odds that a decision in another case may give you even more support for an argument you want to make either to the en banc Federal Circuit or up to the Supreme Court eventually. So this is an important patent. Obviously, it's very, very high value. It's been, I would say, validated in the past by the Federal Circuit, and now it's here on a split decision. I have no doubt that Dan is correct that many in the biotech industry will rally to Biogen's defense here, and it'll be very interesting to see whether or not this gets taken a look at again.
Shall we call it a day with that? I think we're all.
I think that might be it. Do you guys have anything to plug or?
No, I appreciate you hosting this today, and good chatting, and we'll keep following. And unfortunately for listeners and clients, the story goes on. I know people want finality and ending, but that's not always how things happen. So we'll be here. I know both of you like people reaching out. I do the same, either in DMs or on Twitter, and we like doing this stuff. And so anything we can do to help, let us know, I guess.
Yeah, I'll second that. Thanks to everybody for listening. Thank you, Dan. Thank you, IP Hawk, for hosting. And yeah, I'm sure there'll be more developments in each of these cases for us to discuss going forward, as well as other situations of interest to investors. So thank you, and everybody go out there and have a great day and try to make some money.
Thanks, guys.
Thank you.
Bye.